Welcome back. Can I just ask you this? It was hinted at, and I don't want to go into this particular issue on the case, because I don't know if it's going to be taken further one way or another. But just in a general proposition, there was the idea that certain witnesses may be very reluctant to testify because of the cameras.
That is certainly a concern, and during the application for broadcasting, it was raised, and Mlambo JP raises it as one of the concerns that have been raised. And
And what would your advice be to a judge in a situation like that? Say, sorry, you're not going to televise this trial.
Well, obviously the judge, before whom such an application is made, will have to adapt what was done in the Pistorious case, will have to adapt in what has been done previously, will have to adapt the practice manual of the Gauteng High Court in terms of to what extent witnesses should be protected who express unwillingness to testify, because they'll be exposed in the manner that violates some of their rights as well.
You want to say something about it?
Yes, I'm just a little confused because haven't we constructed the court setting to be the most terrifying environment possible, so that witnesses know that they better tell the truth in the face of being held in to...
Oh, that they would, then we wouldn't have problems about credibility.
Yes, but the argument that making this more intimidating, I don't think takes us anywhere. I think it takes away from the fact that the whole point of a court situation is to terrify witnesses into telling the truth. If the argument is going to be that having a camera there now is going to intimidate people, I think that overlooks the fact that it's supposed to be an intimidating
Say that
scenario.
you would accept that in some cases you'd have to clear out all of the cameras because people may have a justification to give the evidence in camera.
No, absolutely. Yeah.
Right, which you'd have to accept.
I do accept.
Which makes it extraordinarily incoherent, the whole thing.
It does, but it does at least say that there's a default position of openness, and you must come with a good reason if you want the cameras out.
Are you arguing for this as a sort of absolute position, or are you saying a judge should be able to decide for himself or herself whether they're prepared to have it?
I think a judge, of course, always has the discretion to deal with matters in his or her courtroom.
Yes, but would you prefer a constitutional court judgment which said all of these trials are open, or would you say it's up to the judge to decide?
I think I would be delighted with a constitutional court judgment that set that ground rule, subject to, and let's not forget that Mlambo did that. He said,
yes,
if the presiding judge wants to change any of this, she can do that. So when Barry were at the end of the
But you would have
trial,
been very cross if the judge had said, "You kidding, I'm not going to have this trial televised, I'm doing it without, I'm an old-fashioned judge."
Well, you see, that wouldn't cut water, because the judge would have to have a good constitutional reason to depart from the Mlambo.
Why? The judge says, I run my trial the way I want to run my trial. I don't like having cameras in my courts.
Well, because it's not up to the judge. Neither is it up to the witness. It's about what open justice requires in our democracy. So a judge must live with it.
So if a judge says, I think that I'm going to be put under greater pressure because I'm going to have a debate with counsel in a particular way, ordinary people aren't going to understand that.
I think that is an...
And I can tell you that happens all the time. You have an exchange with counsel. Mr. Malindi must surely testify to that.
Yeah.
Judge and the counsel have a robust... The layperson doesn't understand what's going on there.
That's why you need people like Professor Grant to tell the layperson what this
There
exchange
were
has all
very
been
few
about.
Professor Grants during the
Yes.
the thing, as I indicated earlier.
And that's why that's an argument for more Professor Grants, but it's certainly not an argument for less television.
But if there aren't more Professor Grants, what do you then do?
But also we need to give the public more credit. People were able to follow what was going on in an astounding way. I found that through my Twitter feeds, I had very ordinary people being able to pick up very complex and intricate arguments in a way that, frankly, surprised me. And I have renewed faith in the public.
Well,
yeah.
I was going to add that I agree with Dario that it's open justice. We've extended court proceedings from one single court. We've created adjoining courts with screens to watch. and television becomes an extension of that courtroom. It becomes an extension of the lekgotla or a public hearing in a village or in a town. However, there are certain other competing rights and interests that must be protected, and that is what this judgment has done.
Can I ask you something? If you're in a case like this, and the cameras are on you all the time, as a defence counsel, are you telling me you don't feel under more pressure?
No, there is pressure, except that if you are a professional, you take into the bargain the fact that sometimes there will be media in the courtroom and you'll be televised.
Most judges find, I'm sure, find the situation that if there are no press at all, it's a much nicer atmosphere.
It definitely is a much nicer atmosphere.
And you get more out of counsel and everybody's very relaxed.
Everybody's relaxed and there's a better exchange rather than being self-conscious.
Now that we come into the end of this program and we look at Pistorious, was it a success? And what could be done better?
I think it was a great success from a broadcasting perspective. I don't think there was any objection by the judge to the way the broadcast happened. I think all the rules that were set by Mlambo were followed. I think it gave rise to some very good analysis by select individuals about what this was all about, which educated
and then
all of
Professor
us.
Grant will tell me afterwards who they were. Okay, fair enough.
And I think it raised the game for the media because it said to journalists, legal journalists out there, if you want to be a good journalist, you can't get away with just telling us what happened in court today. You've got to explain to us what this is about.
Could I then ask you where you think the weaknesses were?
I don't think any of the weaknesses arose because of the broadcast. I think the weaknesses are the weaknesses one finds generally. So as you've said earlier, the question of specialization of journalists so that you can really claim to be an expert in a criminal case. You know, more sort of LLBs for journalists is what we need. I think it's a question of skilling journalists.
Do you accept that if we're going to do this, then the media are going to have to join the party and get better people to do the job?
I think that's absolutely necessary. But I don't think it's a condition. I don't think we should say until we have every journalist covering a trial is educated, we can't have televising because, as James says, that underestimates the public and the public's capacity.
No, we mustn't underestimate the public.
It's also self-selecting. You'll find that those journalists who actually do know what they're talking about are the ones who attract attention. And the public figure out very quickly who knows what they're talking about.
Really?
I believe so.
I'm quite happy to debate with you, but that's the quality of journalism is for another program. It's interesting. The guests here this evening think it was a success. It certainly was unprecedented because it was the first trial. It certainly created more interest than perhaps we ever had in the criminal justice system. Certainly, I would think in my lifetime, and probably in yours, watching this particular program. Whether it was a good thing, I suppose, depends on the fundamental principle, what you consider to be open justice. And what's been argued here is that open justice means we should be able to see inside courtrooms. But there are questions. Should it only be these cases? What about the ordinary people? Surely we need to educate the public in what goes on in the ordinary magistrates' courts and criminal high courts every day. And how do we do that? And how do we educate the public by getting enough people to deal with these particular? Is that a condition, or is that just saying it'll be a good add-on? And what about the concerns about witnesses as we've raised? Well, there are a plethora of issues. And perhaps when you reflect upon them, you can judge for yourself. Goodbye.